Hi, everyone. This is Carrie. Welcome in. I wanted to give you guys an update on the Ferriter trials. And I say trials, that's a plural because mom and dad both are being tried separately. Now, the father, his trial is over. We were all very excited, thinking, this is going to happen. This guy's going to get what he deserves. The judge seemed to really be on point and have a lot of empathy for the victims. And then when it came down to it, you guys, 5 years. 5 freaking years is what he gave Tim Ferriter for what he did to this child. Now, look, if you're new to this case, this is the first video you're watching on it, please go back to my playlist to catch up before coming into this one. I'm reading this out of WPTV West Palm Beach, and it says that they're having a hearing on December 15th. And this actually says, should he be released? Now, I've touched on the idea of these fake letters or these fake jobs that popped up before. I think that was in my last video. But I learned a little something new here just yesterday when I was looking at this. It says a Palm Beach Circuit judge has a date for a hearing on whether Tim Ferriter should be released from jail while his attorneys appeal his conviction and prison sentence. What the hell? These people are so entitled. Why did they think that what? I've never heard this. I've never heard this. If you guys have heard this, if you know more about the law than I do, which I'm there's probably a lot of you guys that do, please explain this to me. It says Judge Howard Coates, who is just, air quotes, let us all down, has scheduled a hearing on the matter for December 15th, right? Coates will likely hear from defense attorney Priya Murad, or Murad, whatever her damn name is, we don't really like her, and appellate attorney William R. Panal on a fabricated job offer from Mazda. Now we know that. We've heard about that. That motion was modified after it was revealed that no such offer existed. They last reported that WPTV last reported that citing the court filing, Ferriter had job offers from Mazda and a company called Dream Outdoor Properties. And they have up here the actual forms that say defendant's motion for release on bond pending appeal and request for evidentiary hearing. Sure, expecting a lot because, first of all, doesn't appeal take some time? And his appeal's not going to go through. Appeal for what? That the truth was heard? It's a bunch of crap. Now, the Dream Outdoors property, I did read this in another one. It said basically, thank you for taking time out with us. We're confident you can make an important contribution to Dream Outdoor Properties, and we would like for you to join us as an employee in the capacity of sales assistant based out of our Jupiter, Florida office. That was dated November 1st of this year. However,
Ferriter's attorneys want him released because he's asking for a new trial. They argue he could do one of two jobs. But one of those job offers we found is not real.
It was a complete and utter forgery.
The attorney from Mazda Palm Beach say this letter offering Tim Ferriter a sales position is a fake. Attorneys for Tim Ferriter submitted this letter and another job offer to prove he had employment options if he was released on bond. We also called the other company with the job offer called Dream Outdoors Property. The website lists 4 different numbers, but each time we tried calling one of those numbers,
Verizon Wireless, your call cannot
is
be completed as
disconnected.
dialed. Please check the number.
The website also only lists one office that we could find, and it's in Colorado. There is a manager listed on this employment letter and a larger real estate company. We tried to reach out to both of those entities, but was ultimately unsuccessful. We obviously want to talk with Ferriter as well, but he's behind us tonight in the Palm Beach County Jail. In Palm Beach County, Ethan Stein, WPTV News Channel 5.
okay, shout out to Ethan because he just did a great job on that. Now, his attorney, Miss Slick Attorney, I swear I think she's so shady. She is so shady. All right. She has maintained that she was unaware that the job offer was fabricated. Ferriter was convicted last month on charges of child abuse, child neglect, and false imprisonment. Prosecutors convinced jurors during Ferriter's trial that he treated his 14-year-old adopted son like a prisoner in their Jupiter home, forcing the boy to sleep in an 8x8 window, nothing but a mattress, a desk, and a bucket in which to defecate. The only time he was allowed out was to go to school. I think they should also make note that the child had no controls on the lights in the room or the AC in the room, or the lock for that matter, because it was only from the outside. Coates sentenced Ferriter to 5 years in prison, which was less than what the state had sought, but more than his attorneys had requested. Defense attorneys unsuccessfully sought to have Ferriter released from jail while he awaited sentencing, but the judge denied that request. See, when he denied that request, we were like, oh, yeah, this judge is going to really put it on him, right? The Fourth District Court of Appeal will decide whether Ferriter should receive a new trial. Meanwhile, a January court filing revealed that Ferriter is being sued by his former attorney, Nellie King, and the complaint alleges that Ferriter retained new counsel to represent him in August of 2022 and has refused to pay the final installment of $62,500 as required under the agreement he signed with King shortly after his March 2022 arrest. This is an action stemming from defendant's breach of representation agreement and related claims in excess of $50,000. They're basically stating that the attorney's fees and costs, which are the subject of this action, were earned by firm during said representation. On or about March 23rd of 2022, the firm and Ferriter entered into a contract with the firm providing legal defenses in the criminal and companion civil cases referenced above. A true and correct copy of the contract captioned representation agreement is attached. Pursuant to the agreement that Ferriter entered into on March 23rd of 2022, Ferriter obligated himself to pay a phased, non-refundable flat fee of $125,000 to the firm upon execution of the agreement. The agreement called for the payment of the total fee in several installments, with the last of said installments for $62,500 due and owed on December 1st of 2022. As the agreement clearly states, the total fee was non-refundable, regardless of whether the firm finished the cases through the trial. After entering into this agreement, the firm began representing Ferriter and worked diligently and vigorously to obtain the factual and legal information necessary to pursue the defense of the pending cases. On or about October 17th of 2022, Ferriter retained a new counsel to represent him in the cases and has refused to pay the final installment of $62,500 required under the terms of the agreement. So that's what this lawsuit is about against him. Now Tracy's like, "Oh, we don't have any money." She can't defend herself. She supposedly had an attorney that actually even was there during her husband's trial, sitting next to her, kind of taking notes or whatever. And I think they're out of the mix. So let's go back to what's going on with her, because she had a hearing yesterday, Friday. She's facing the same charges. Let's now go over to what's going on with mommy.
With respect to what is currently pending before the court this morning, Ms. Marshall, is the court correct in presuming that the only matter left for hearing now is the amended motion to withdraw and motion to continue to allow the defendant to retain new counsel?
Yes.
Okay, so with that, I'm going to let you go ahead and proceed to make your argument on that motion.
Your Honor, at this point, circumstances have arisen that have caused an irreconcilable difference between my client and I, and the circumstances are such that I believe there is a mandatory requirement to withdraw, and I'm moving to withdraw based on those grounds at this time.
Okay, so let me just ask a few questions, because earlier in the week, your motion was primarily based on the fact that you had received a job offer, I think, from ORCC, and I had asked you to go back to them and find out if the trial in this matter were to proceed in early January, if that would create any problem with them continuing to make the offer to you, and that you could report immediately after the trial. Am I to understand that with the amended motion that is not really the crux of the motion anymore, but it's founded on some other legal point like irreconcilable conflict or something of those along those lines? Because as you know, the legal matrix between considering the two is very different. And so if you're telling me that there's an irreconcilable conflict in representing your client at this point that has now been created by the circumstances, then I'll have to assess that under a different legal standard than I would have assessed just the convenience issue.
Yes, Your Honor.
All
That
right.
is correct.
Okay. All right. Ms. Coakley, what is the state's position in regard to this?
I don't have any further, based on the second ground, I leave it in the discretion of the court. I will say that Your Honor should not address any motion to continue at this time.
Well, I'm actually going to deny the motion to continue until you've represented at sidebar that Mrs. Ferriter already has counsel ready to appear. So I'm going to set a status check and have that new attorney come in on an immediate basis. And my intentions are to proceed forthwith as promptly as possible, because even though ultimately, under the circumstances, I think, unlike what I would have done with just a convenience and probably denied the motion to withdraw and push this thing to trial, if there's a conflict, I need to take a more serious look to that. And so I would likely be granting the motion to withdraw. In fact, I am going to grant the motion to withdraw based on the fact that there's a conflict that's been represented to the court. However, I am going to deny without prejudice any motion to continue. I'm going to give the defendant, Mrs. Ferriter, 10 days from today's date to have her attorney file a notice of appearance. And any attorney that she retains should be prepared to address the court as to how quickly they can proceed to trial. And given the fact that any attorney taking this case is going to be taking it with the knowledge that it's already currently set for trial, I'm going to want to inquire very significantly as to if they take the case and they know they can't go in early January, why they took the case. So right now, the motion to continue is going to be denied without prejudice. And I will set this for status check. I'm saying 10 days, that gets us to, let's set it for status check Monday, December 18th. And that'll be purpose for determining status of the defendant, Tracy Farer's counsel, and also for addressing any trial matters that may need to be addressed prior to the January docket, because right now this matter remains on the January docket. Anything else that I need to address from either you, Ms. Marshall, or you, Ms. Coakley?
Would you consider setting the status check for next Friday, since we already have, or is that?
I don't have a problem setting, the next Friday is what, that's the sentencing hearing. I don't have a problem setting it for next Friday. That's a little shorter than the 10 days. I just wanted to make sure that, but according to you, Ms. Marshall, the 10 days really is not really necessary because she already has somebody waiting to make an appearance.
She hasn't submitted a retainer, to my understanding, and he hasn't.
Has not?
Right, but they
Yeah.
are in verbal agreement.
Yeah, I want whoever is retained, though, to be informed in advance that this case is currently set for trial. It's been pending for quite a while on the trial docket. This, with no adverse judgment on you, Ms. Marshall, this is a very, very late filed motion to withdraw, literally on the eve of trial. It does disrupt the court's calendar. It impacts the orderly administration of justice. So I say all those things for the record, so that it's clear that granting a motion to continue is not a foregone conclusion in this matter, and it should not be a foregone conclusion by any counsel willing to step forward and represent Ms. Ferriter in this matter, and they're going to need to know that in advance, and that's why I'm denying it without prejudice. They can come in and make their arguments, but given the nature of this matter, how long it's been pending, and the judicial resources that have been necessary to bring these matters to trial, my strong preference would be not to continue unless I'm persuaded that I really have no choice in the matter. So that's kind of where I stand on it. Anything else? And so we'll set the status check instead of the 18th. We'll set it for next Friday. What time is the sentencing hearing scheduled for? So we'll set it. The bond motion, yeah. So we'll set it at the same time that the motion for appellate bond is set for next Friday, and that is the 15th at 10:30. All right, and just prepare an order this morning, Ms. Marshall, that indicates your motion to withdraw is granted. The motion to continue is denied without prejudice. All right, okay, all right, thank you very much.
What did we learn? Well, I thought the whole point of her withdrawing with her current attorney was because she was saying she didn't have any money. But the 15th, which is next Friday, so it's only a couple of days away here, is when we're going to hear about his bond release. So ridiculous. And I guess at the same time, they're going to be doing the status hearing for her as to what's going on with her attorney assignment. I thought she was supposed to get a public defender because she was saying she didn't have any money. Have they filed bankruptcy? I'm sure that's what they're going to do. I did hear that they sold their house. I'm gonna be honest, I'm not sure. Now, this coming Thursday, we have a status hearing for Daryl Brooks. So if you guys also are interested in that, I'll have a live stream on that. I'm not gonna have a live stream on the Ferriter. I'll just keep you guys updated as to what's going on. The one thing I wanted to just state really quickly is that, in my opinion, I'm disappointed that this judge is the same judge on this case for Tracy's trial, because we know the outcome now. We know what's going to happen. I feel like she's going to get a slap on the wrist. And a lot of people think, well, she's just going to plea out. And she may. If they offer a plea, she'll plea out. But do they have to offer a plea? They don't have to offer a plea. And I can't see the state. I don't know. I just feel like, why would they offer another one? Unless it was a matter of, let's not put the kids through this again. Let's just let her plea out. She's going to get a slap on the wrist, you guys. This is going to disappoint all of us. And once again, this child is going to be disappointed by the system. Big shocker for us all, right? That's one way to start off the day. Damn it, that makes me angry. Anyway, I appreciate you guys listening, and stay tuned for the next one. See you soon.